Hi everyone, it's Amy here from the blog I Think Therefore I Teach. Welcome to your next instalment for Criminology. This one is Unit 3 and it is 2.2. Now, for some reason I've left this one till the end and it's actually a really straightforward topic. It's just a bit dull, it's very dry, so I've only just really finished tweaking the PowerPoint, but hopefully it might help you, especially if you have your control assessments coming up shortly. So let me make myself smaller and we will get cracking. Alright, so describe the trial processes, Unit 3, Topic 2.2. You need to talk about all of these areas. You need to talk about pre-trial, bail, roles, plea bargaining, courts and appeals. You have to have knowledge of each of these stages, including the roles of the personnel involved. So very, very straightforward. It's not an assess, not an evaluate. It is just simply show knowledge of each of these areas, emphasising the personnel or the people involved. So you have three types of offences to begin with. You have indictable offences, which are the most serious. The initial hearings in magistrates' court, but must be tried in a Crown Court. These are your murder, rape, robbery. Summary offences, these are less serious. They are heard in magistrates' courts. These are things like motoring offences and minor assaults. And then you have triable either way offences. These can be heard in either magistrates or Crown Court. Higher sentencing power in Crown Court, so again they can give harsher sentencing, but greater chance of acquittal by a jury than trial in magistrates' court. So if it goes to a Crown Court and they see a jury, chances are they'll just get off with nothing. Whereas if it's magistrates, they're more likely to get some punishment, some sentencing, fraud, handling stolen goods, etc. Pre-trial matters then, the decisions magistrate courts take before a trial. Pre-trial review points of law, e.g. whether certain evidence is admissible. So will the evidence get through? Guilty pleas. The magistrates hear about aggravating or mitigating circumstances, then pass sentence, await reports or refer to the Crown Court. And then not guilty pleas, the decisions about legal aid and bail before trial. So if it's guilty, it just goes through the following procedures. If it's not guilty, they then have to make decisions about the legal aid and bail before the trial. So there'll still potentially be a trial, even if they say not guilty. Then they need to look at things like bail and, are they a flight risk? Bail, this is temporarily release a suspect before a trial. An innocent until proven guilty, Section 4 of the Bail Act 1976, they have a right to bail. Custody officer can refuse bail if the suspect's name and address is questionable, so if you don't actually know who they are or where they live. Unconditional bail, court imposes no conditions other than you have to attend court on this date. Conditional bail, they must agree to the terms and conditions, such as a curfew, they must hand over their passports so they don't flee the country, report to the police station every day so that, again, they can keep a very close eye on them. And they can remand in custody, so they can be sent to prison for that period of time if the court refuses bail or suspects breaches might happen in the conditions before the trial. So if they think that the person is a flight risk, then they'll remand them in custody, they'll keep them. There are a number of reasons that bail may be refused. So again, I got my students to try and think of 6 reasons why bail might be refused and gave them a hint that there's 6 main ones. So I got them to come up with as many as they could. The court may refuse bail if likely to fail to surrender to bail, so not turn up in court, previously denied bail or not met bail conditions, likely commit offences while on bail, could obstruct course of justice, so interfere with the witnesses, so again they'll know who the witnesses are, they could find ways to threaten them or intimidate them. Serious charges, murder, they are not going to be let back into everyday public, because again if the public found that a murderer had been let loose on bail, there'd be extreme problems. Custody for their own protection, if actually them being outside would be a risk to their health or their lives. And so magistrates will consider many factors, including character, background and associates of the suspect. So they really do look at the big picture and whether bail is a valid and viable option. Plea bargaining, an agreement between the prosecutor and the defendant where defendant agrees to plead guilty for a concession, a lessening of the sentence, for example. Charge bargaining, guilty to less serious charges, so then get a lighter sentence. Court bargaining is where they plead guilty to one charge in return for others being dropped. Sentence bargaining, they're guilty to original charge but they want a more lenient sentencing. This is the incentive to plead guilty and avoids potential of lengthy trials trying to not guilty, find them guilty and go through it. It just goes straight into guilty and then they can work with what they've got. Courts. I got the students to write an overview of the different sections of the criminal court: justice system, magistrates, crown, jury and judge. We've done this many times. It comes up in future topics and it came up in previous topics. So I got them to focus on the roles and the personnel involved. Again, it was purely descriptive and explanatory, so I got my students to research that. We also watched a couple of clips, one about the magistrates court, one about the crown court. Again, if you just Google them, they come straight up on YouTube. Very easy and plenty to watch on there to help. Finally, you've got the appeals section, the magistrates court. If convicted in a magistrates court, you have two automatic rights of appeal. The first is against the conviction, needed to plead not guilty. The second is against sentencing. So against the conviction and against the sentence, they don't like the sentence that's been given to them. You must appeal within 21 days. Appeal is heard as a retrial in court by a judge and two magistrates, so a judge and two magistrates rather than just the magistrates. The court can uphold or squash, let it go, the conviction or vary the conviction to a greater or lesser extent. So you could appeal against sentencing, for example, and they could put the sentencing up. So it won't necessarily get quashed or go in your favour as in going down either. So it's a risk that you've got to take. Reduce or increase the sentence, and if you lose, you can further appeal, but you must get leave, permission to do so, and on a point of law. So there must be a reason why the law has not been followed in order to reappeal again. But you have to then get permission, so you have to have a blooming good reason to get through a reappeal. Court of Appeal. Appeals against Crown Court verdicts are handled here. So any appeals against the Crown Court, the verdicts, the guilty, not guilty, are handled here. Decision made by a judge whether to allow the appeal or not must apply within 28 days. Both conviction, unsafe and sentencing. So the appeal can be both on the conviction if the conviction is seen as unsafe and the sentencing that's given. No jury in the appeal. 3 judges. So that's pretty as high up as you get. 3 judges. Prosecution can appeal if error in law made by the judge, the jury, tampering involved in duly lenient sentences or new compelling evidence. So the prosecution can appeal, so it goes to the 3 juries. If they believe in the first case there was an error that was made by the judge, the jury, there was some tampering involved, they thought the sentence was just unfair, or new evidence has come forward. Supreme Court, this is the highest court in our legal system. No automatic right to appeal to Supreme Court, and normally if it's only of public importance and the public importance is at risk, will it actually ever get to the Supreme Court? I hope you found that useful, everyone. Please do not forget to give me a thumbs up and subscribe so that you never miss out on a video, and feel free to drop me a comment or a question underneath, and I'm more than happy to respond to them as and best I can. Otherwise, thank you very much for watching, everybody. Bye for now.